Hi, I am Isaac Elliott, representing the defendant, Mather Organic Distillery, in this breach of contract dispute. Though my client delivered 10 crates of the requested gin on time, Maud was not paid the agreed-upon purchase price. The plaintiff claims that they subtracted 15% of the purchase price from the check because they made payment before the agreed-upon date, a provision they claim was agreed upon in a phone conversation which took place on the day the written agreement was made, and they are seeking to introduce evidence related to this phone conversation. However, all evidence gained from this conversation is barred by the Parol Evidence Rule. Under UCC 2-202, the Parol Evidence Rule applies to confirmatory memoranda set forth in writing that are intended as a final expression of such terms that are included therein. Here, there is a written contract that states that it is the complete and exclusive embodiment of all terms agreed to by and between the parties, so it is clear that this contract was intended to be a final expression of the terms within it. UCC 2-202 also states that this final expression cannot be contradicted by any prior agreement or any contemporaneous oral agreement, but does not bar any subsequent agreements. In this case, the phone conversation occurred on the same day that the written agreement was signed. Since the conversation took place within the same period of time that the written agreement was formed, any oral agreement formed was contemporaneous to the written agreement and falls within the scope of the Parol Evidence Rule. Finally, UCC 2-202b states that a final expression cannot be contradicted by extrinsic evidence, but may be explained or supplemented by evidence of consistent additional terms, unless the court finds the writing to have been intended also as a complete and exclusive statement of the terms of the agreement. In this case, the written agreement was clearly intended to be a complete and exclusive statement of the terms of the agreement. The agreement included a comprehensive list of terms and explicitly stated that it was the complete and exclusive embodiment of all terms agreed to by and between the parties, and both Maud and Ginger signed this agreement. Since this document was intended to be a complete and exclusive statement of terms, any evidence of additional terms is barred by the Parol Evidence Rule. The plaintiff also claims that Maud's gin is not all natural, as they claim, because it contains trace elements of GMOs. However, small traces of GMOs are not uncommon in gin, and the amount present falls within the range that is expected by industry standards. Maud has identified expert witnesses who would testify about their experiences within the distillery industry, but plaintiff has claimed this testimony is barred by the Parol Evidence Rule. UCC 2-202 bars the contradiction of a written final expression by evidence of any prior agreement or contemporaneous oral agreement, but states that an agreement may be explained by course of dealing or usage of trade. UCC 1-303C states that a usage of trade is any practice or method of dealing having such regularity of observance in a place, vocation, or trade as to justify an expectation that it will be observed with respect to the transaction in question, and that the existence and scope of such a usage must be proved as facts. In this case, there is a practice within the distillery industry that has been regularly observed that all natural gins may still contain small, trace amounts of GMOs. This expert testimony is being introduced to prove the fact of this industry norm that has long been in place and does not contradict any terms in the written agreement, so it is not barred by the Parol Evidence Rule.